Hello, I'm Jenefer. I'm the founder of Silk Helix, and today I'm answering the question, what happens when an employee won't sign their employment contract? Or indeed, you just realise years down the line that it's never been signed. It just didn't happen. It didn't get chased up for whatever reason. To start with, let's look at what is an employment contract. So an employment contract fundamentally is when you offer somebody work for wages. So you're going to pay them to come and do some work. They agree to come and do that work for you. The agreement is made. You've got an employment contract. It can be verbal. It doesn't even have to be in writing, let alone signed. Having said that, there is kind of requirements to provide information in writing, and there's benefits to providing an employment contract. Really briefly, because I have got another video on how to write an employment contract. The link to that is in the description. Take a look if you want more details about what an employment contract is and what it should contain. But really briefly, the Employment Rights Act, Section 1, says that you have to provide a statement of particulars by the end of day one of employment with a list of information that you have to provide. So that includes things like the name of the employer, the hours of work, the pay they're going to receive, that kind of thing. There's an extensive list. There's also an article that I'll put a link in the description to as well. That has to be provided, and ideally the individual will sign that to say that they've received it, so that you've got evidence that you complied with the legislation and you provided it to them. I recommend that you go further than that and that you actually issue a full employment contract which states your contractual terms. So covers things like a deduction from wages clauses. So should you need to deduct from wages, let's say for excess holiday taken or damage through negligence, you've got the ability to make those deductions. Also worth putting in things like layoff clauses, short-time working. So should the business hit hard times, for example, what we've been through with COVID the last few years, that you've got the ability to adjust to lay people off of work on a short-time basis to be able to cope with that. And those things are about protecting the business, and having them in the employment contract makes it really clear to people that that's what you could do, and actually the only way you can do it is with their agreement, i.e. with the employment contract. The statement of main terms, as I said, only has to be issued at the end of day one of employment. The problem with this is you verbally offer somebody a job, they accept, they come to work, and then they realise that they've now been given this document that has terms in it that they possibly don't want to agree to. You've now got a problem. They're at the end of day one of employment. They've given up their last role. They've come to work for you, and they probably feel a bit tricked because you've now tried to put terms in that they weren't aware of. So it's always best to issue that prior to them starting. These are the terms and conditions of the contract they're entering. It's only fair that we all get to see the small print before we sign a contract, i.e. before we start work. So one of the ways to solve it is that you issue the employment contract before somebody starts work, and that they accept the job by signing that contract of employment, and therefore you've got something that's signed and in place. The reality is, I know that doesn't always happen, and there are many times that an employer will come to me and say, they never actually signed their contract. I realise I've only got a non-signed version on file. In that situation, as long as you can evidence that you issued the contract and they're aware of the contract, then it'll be deemed that they agreed to it because they've carried on working, they've carried on providing their labour, they've carried on receiving the pay, and therefore they've agreed to the terms of that contract. And you'll be able to enforce the terms of that contract. It's better to have all of that in writing. So if you issue somebody with a contract, let's say on day one, and they just don't sign it, they don't raise any issues with it, they just, it's at home, I'll bring it in tomorrow. And it gets left on the kitchen table. For some people, it's just not important. There are people who don't sign employment contracts and won't sign them, and I don't really know why. I think it's some kind of belief that if they don't sign them, it doesn't exist. That's not the case. It doesn't help an employee in any way not to sign it. If they continue to come to work, if they don't raise an objection and just don't sign it, it will be considered agreed to. You can cover yourself as an employer by writing a letter that says, we gave you a contract, we want it back by this date, can you sign it and send it back to us? If you've got any issues with it, raise them with us. And then a further letter that says, look, you've continued to work, you haven't raised any issues with us, and therefore we are deeming this to be agreed to. So that covers you. It provides you with an extra basis to say that you did everything you can to get that contract signed. You've got your evidence that you issued it, that they saw it, they had the chance to raise issues with it, and they just didn't do so. If somebody is raising issues with the contract, if they're concerned, if they're what we call working under protest, so they're saying, well, I'll continue to work, but that particular clause I don't agree with, it's best to try and resolve that matter. It's best to try and reach agreement with them somehow. And the reality is that should it come to an employment tribunal, there is a possibility that the tribunal would consider that that particular clause has never been agreed to. And there is some case law around particularly flexibility clauses, and somebody continuing to work, they were working under protest, but when their employer tried to move them to a different location, enforcing a flexibility clause, because they've been working under protest and not agreeing to that flexibility clause, the employer wasn't able to enforce that flexibility clause. It was deemed that that bit had never been agreed to. So it's better to resolve these issues rather than down the line saying, oh, well, just you carried on working and therefore we deemed you to have agreed to it. If somebody is objecting to a particular clause, you need to reach agreement on that, and you need to consult with that. So what we're saying is an employment contract doesn't have to be signed to be enforceable. It's better if it is. It's clearer for everybody if it is. It doesn't even have to be in writing. Although, of course, if it's not in writing, it's going to be really ambiguous. There's going to be lots of disputes about what's actually there. Whereas when you've got it in writing, it's really clear what's intended. And it's always better to get it signed, because that way you know you've got a paper trail, you issued it, they've said they'll agree to it, and there is much less chance of disputes as a result of that. That said, what you can't rely on is suddenly saying, oh, we're just going to change the contract. It doesn't matter if people don't sign it, they'll carry on coming to work and we'll just say we've changed the contract. It doesn't work like that. So you can't unilaterally change somebody's terms and conditions and rely on the fact that, oh, we issued it and people just didn't sign it. So if you are looking to change terms and conditions, that's a separate video, a separate discussion. We would need to go down the process of consultation and try to reach agreement for changing those terms and conditions. So be aware that that is a very separate issue that we're not going into. What we're talking about in this video is when you've issued a contract, usually to a new starter, but it could be something like a promotion as well, where you've issued a new contract and somebody just hasn't signed it, but you've got the evidence that you've issued it and they've continued to work, they've not raised any issues, the contract's deemed signed.